Good morning and welcome to the March 14th, 2023 session of the Senate Judiciary Committee. We're going to open our day with Senate Bill 605, and Senator Bradley is not available, and Senator Susi has very kindly agreed to introduce the bill. So I'm going to call Senator Susi. Senator Susi, welcome to Senate Judiciary.
Thank you, Madam Chair, members of the committee. For the record, I'm Donna Susi. I represent Senate District 18, and I appear this morning before you on behalf of myself and Senator Bradley. This bill came about, it's a late bill. It came about as a result of an opinion that had been rendered by the Ethics Committee about what process, what criteria should be involved if a legislator is to recuse themselves. Not if, but it actually said that a legislator had to recuse themselves under certain circumstances. With due respect to the committee, I think both Senator Bradley and I believe that the committee exceeded its authority, its current statutory authority. But we do recognize that there are instances where legislators should step back and recuse themselves because the benefit to them personally is so substantial. We've gone back and forth, I think, over the years, because it's really, it's a difficult needle to thread in a legislature that is made up of volunteers. We know our compensation is $100 a year. We want full transparency. We want to disclose things to our constituents. But to the extent legislators are forced to recuse themselves, there are some instances where it would render us incapable of doing our jobs effectively for our constituents because in the Senate, for example, there are so few of us. So this legislation, drafted with a great deal of assistance from Senate Legal Counsel, relies on definitions that are currently in place in the federal IRS statutes and tries to set out very clear criteria for recusal. If you look starting on line 9, the reasons that a legislator should recuse themselves includes financial remuneration, exercise of substantial influence, which is defined in the next paragraph, and that the organization has lobbied, testified, or attempted to influence the outcome of official legislative activity. So we tried to narrow the possibility as much as possible. We're not trying to capture everyone that works for a school district, for example, or some major institution. There's actually an exemption in the statute for folks that work for government institutions. But we tried, I think, very diligently, as I said, to very narrowly, but yet clearly define the circumstances by which a legislator would need to recuse themselves. Since that initial ethics opinion came out, there have been a couple other opinions rendered that I think sort of, once again, try to better define the circumstances. But this was our attempt to deal with what we thought was a decision that went too far and that needed to actually be placed in statute so that all of us could have an informed discussion about what should constitute a recusal policy. So with that, I'd conclude my testimony. I'm happy to answer any questions. As I said, Senate Legal Counsel worked on the drafting of it, and I did note that Mr. Lambert is here from the Ethics Committee as well. So to the extent that there are some practical questions, they may better answer them than I, but I'm happy once again to always respond where I can.
Thank you very much for your testimony, Senator. Senator Gannon has a question.
Thank you. So if we go to lines 7 through 9,
Yes.
so I'm a legislator. My wife has taken a lowly job with the insurance companies when she used to have a much bigger one. So she works out of home just doing customer service so she can be at home with the kids. But so she receives financial remuneration from them. But she does no longer has substantial influence. But I would think then I couldn't vote on insurance bills. Or am I reading it wrong?
Senator, because
Okay.
if you look at the end of line 10,
Okay.
it's and. So your wife, you or your
And,
wife
okay.
would have to meet all three of those
All three.
criteria.
Okay, I
Not just
understand.
one, but all three.
Okay, great.
And the influence substantial, as I said, starts on line 16. You have to be a voting member, you
Okay.
have to be an officer, or a treasurer or chief financial officer. So
Gotcha.
it really limits,
Okay,
I think, in an appropriate way, who would be in a position to recuse themselves.
understood. Thank you, Senator.
Are there any, Senator Chandler?
Thank you very much, Madam Chair. On line 11, where it says the organization has lobbied, testified, or otherwise attempted to influence. And I'm assuming the otherwise attempted to influence may be providing some kind of written persuasion. So what I'm thinking is, if that organization wrote to an individual senator or a committee of the House, would that count as otherwise otherwise attempted to influence?
So I think it could, Senator, but I think in each instance, it would be very fact-specific as to what level of persuasion or if there was an ask. For example, I think you could write to a legislator and say, just so you know, these are some circumstances by which we operate. Without making an ask, I don't know that that would be considered trying to influence, but it could be. I mean, I do think these instances are going to be very fact-driven and fact-specific, but this, to the extent that we've established the criteria, is really an attempt to try to help an individual legislator work through what their issues are. Now, there may be instances, I know in the past, I've talked to Mr. Lehman before about certain votes, and that counsel, I think, is always available to members in ethical quandaries. But I think it would depend, is my best answer for you.
And if I may follow
Yes.
up, because I guess I envision a situation, and my question is, could you imagine as well, where perhaps a letter is written to a particular senator and another senator is unaware of that, the person who may.
Absolutely. Absolutely. That frequently happens where one of us will receive information from a particular constituent, and we might choose to share it with everyone else or testify to, but that doesn't mean they were trying to influence you. It only means they were trying to influence the one individual that they communicated with.
Thank you.
Are there any further questions? Senator, just, I think just for the sake of transparency, I am one of the individuals that asked for the clarification because I am, I guess you could say, a part-time employee of the community college system. I tend to recuse myself and usually say I work there. So I'm glad this has come forward. I think this is extremely helpful for individuals. But me as a legislator and as an employee is, even though if this should pass and become law, and I choose to continue to say I have a conflict of interest, but I'm going to participate, am I still going to be able to choose to do that if I want?
Well, if you look at the language on line 7, it says shall recuse if all of these circumstances apply. However, I think there is an exception for your specific circumstances, and I believe that's what one of the recent ethics opinions determined, that in the case of a governmental entity, there is an exception.
Thank you. I did have another question about nonprofits, but I think probably Mr. Lambert would probably be able to answer that much better than you
And
could.
I would be happy to defer.
Thank you. Are there
Thank
any
you.
further questions for Senator Susie? Seeing none, thank you very much, Senator. Mr. Lambert, would you like to just to come up and be available for questioning? Okay. Just so the public, well, Mr. Lambert, you get to introduce yourself.
Yeah, I'm Rich Lambert. I am the Executive Administrator of the Ethics Committee and have been for 30-something years. Madam Chairman, to answer your question about your situation, should this become law, you could still fill out the Declaration of Intent form and choose not to participate. That won't change, is my understanding.
Okay, thank you for that, Mr. Lambert. I wanted to make sure, because the language does say shall, and just say, if I choose to, that it would be okay.
Yes.
So, thank you. Does anybody have any questions? Mr. Lambert, one of the things that tends to happen is we get asked to serve on boards of nonprofits. We are not paid in any way, and some of us end up becoming an officer of that organization, whether it's, you can be the president or chair of the board or vice chair or something. How is that going to work? Because sometimes these organizations come up and they lobby in front of us. So do we have to recuse ourselves? I know that the good senator had said that you must meet all three elements here. So that they have to hold to a position to exercise substantial influence, and the organization is lobbied, but you don't get paid. Do you think that it would still be appropriate, really on the side of caution, to say, I am a member of this organization, or I am an officer of that organization, or do we even need to do that?
I see that in line 3, they define organization to include, in line 4, nonprofit
Okay.
entities.
Mm-hmm.
And currently, membership on such entities falls under the category of non-financial personal interest.
Mm-hmm.
And so if you do have a fiduciary responsibility to an organization, such as you describe, you need to disclose that, either on the specific form for non-financial personal interests
Mm-hmm.
or filling out a declaration of intent form before you participate. That's the current law and guideline.
Okay.
And so going forward, it sounds as though, yes, that would be an issue for recusal if all three of those criteria are met.
Okay. All right. Are there any further questions for Mr. Lambert? Okay. Seeing none. Thank you. Are there any other members of the public who would like to testify on Senate Bill 605? Okay. Seeing none, I'll close the public hearing. We're going to go ahead and open the public hearing on Senate Bill 601. The prime sponsor, Senator Ricciardi, is not available. So Mr. Daley Frenette is going to introduce the bill for Senator Ricciardi. Good morning.
Good morning, Madam Chair and members of the committee. My name is Daley Frenette, and I am the Senate Majority Caucus Director. I'm here to introduce Senate Bill 601 on behalf of Senator Ricciardi. This bill seeks to address the endless stream of spam and fraud emails flooding the inboxes of Granite Staters. Since introducing this bill, Senator Ricciardi has heard concerns from New Hampshire businesses about the technical and logistical challenges of state-based statute tackling this problem. That being said, Senator Ricciardi asked that the bill be referred to interim study so that stakeholders have time to craft a New Hampshire solution for consideration next year. Thank you for allowing me the opportunity to speak. If you have any questions, I'd be happy to bring them to Senator Ricciardi and get back to you.
Thank you very much, Mr. Frenette. Are there any questions? Okay, seeing none, Thank you. Brandon Garrod. Good morning, Mr. Garrod.
Red is on, right?
Pardon?
Red is on.
Yes.
Counterintuitive. Yeah. Good morning, Madam Chairperson, members of the committee. My name is Brandon Garrod. I am a Senior Assistant Attorney General, Chief of the Consumer Protection and Antitrust Bureau at the New Hampshire Attorney General's Office. Here this morning, neutral on SB 601, just here to really point out a couple of concerns, which may be the concerns that were brought to Senator Ricciardi's attention from local businesses, but specifically from a law enforcement perspective. Without speaking to the intent or the purpose of the bill, I think that enforcing it in its current form would be very problematic. And the primary reason is because the linchpin of this bill, which defines certain categories of unsolicited emails as needing, certain disclosures in order to avoid being an unfair or deceptive act or practice in violation of New Hampshire's Consumer Protection Act. The linchpin there requires that the sender does not have an existing business relationship with the recipient. But the bill makes no effort to define what an existing business relationship is. I think that if the Attorney General's office were to receive complaints from, recipients of emails that they claim they did not authorize, they don't want, and they don't have a prior existing business relationship with, there would be easy cases, such as in scammers, who the recipient has had no prior contacts with. But then there would be an enormous body of gray area cases, which, in my personal experience, I believe makes up the overwhelming majority of what we consider to be spam or unwanted email, which is, you buy a product online from, some online merchant, they add you to their email distribution list, and for the rest of your life, you're hit with countless emails from this business. However, you have previously transacted and engaged with that business, so whether or not you have a pre-existing business relationship with that sender is an open question that I think needs to be defined in the statute so that the Attorney General's office has a clear understanding of which emails rise to the level of unfair and deceptive act or practice and which don't. And perhaps more importantly, so that businesses have an understanding of when they can send emails to prior customers and when they can't. I think the majority of unwanted or unsolicited email comes in that form. You've given your email address out to someone at some point because you either wanted their services, wanted their products, and arguably you have a pre-existing business relationship as a result of that. So I think a clear definition there would make this enforceable both to the AG's office and make it something that businesses would more easily be able to comply with, to ensure that they're promoting their products while at the same time not violating the law. The only other point I wanted to make, we did do a detailed fiscal note on this, which I think outlines the likely increase in resources that would be necessary to enforce this at the Attorney General's office. But I just want to underscore, this particular bill goes out of its way to make each separate unsolicited commercial email transmission to a recipient a separate violation of the statute. So if this were defined in a way where, say you buy one product at one point and then, 6 months later, a business blasts emails to every single person that's ever bought a product. If that was a violation of the statute, you could be looking at thousands of violations instantaneously just with that one email blast. So this bill particularly has the potential to substantially increase the number of complaints that our Bureau is required to review and investigate. Happy to take any questions.
Thank you for your testimony. Are there any questions? Sir, does this bill create a private right of action for everyone who feels aggrieved?
It does. It creates a private right of action, but somewhat limits the available remedies from those that are traditionally available under 358(a)(10), which is the private right of action under the Consumer Protection Act, but does make it available. So a person who receives a commercial email sent in violation of this section may bring an action in appropriate state court for either or both of the following: an injunction to stop future emails or recovery of actual damages for each violation, or up to $250 in damages for each violation, whichever is greater. So the existence of a private right of action would, somewhat mitigate the responsibility of the AG's office in reviewing all of these complaints, but I do think there is still the potential there for a significant uptick in complaints.
Thank you. Are there any further questions? Okay, seeing none, thank you very much for your testimony. Are there any other members of the public who would like to speak to Senate Bill 601? Okay, seeing none, we'll close the public hearing. The committee will be in recess for 15 minutes. the committee will come out of recess. Can I get a motion for, to move into executive session? Moved by Senator Chandler, seconded by Senator Gannon. Maybe it might be easier to take the two that we heard this morning. We have Senate Bill 605. Is there a motion on Senate Bill 605? Senator Gannon moves ought to pass, seconded by Senator Whitley. Oh, Chandler. Okay. Is there any discussion on Senate Bill 605? Senator Whitley?
Yeah, thank you, Madam Chair. I think this bill is a really important clarification. I think a lot of us, have other obligations outside of the State House. I know I, like Senator Carson, am an adjunct at the law school. And, I think we want to both maintain a high ethical standard and also allow people to support their families. So I think this is an important clarification.
Thank you. Are there any other comments? Hey, I personally would like to thank Mr. Lambert for being here this morning. We have an excellent ethics department. They're always available to answer any question. And so, again, I'd like to thank you for being here and helping this get clarification, not only for the legislators, but for the public at large that follow us. Appreciate that. So are there any further comments on Senate Bill 605? Okay, we have an ought to pass motion. All in favor say aye. Aye. Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Are there any further discussions on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, I will take this one out. Okay, next we have 601. I'd like to make the motion of interim study, seconded by Senator Gannon. I think that based on the testimony we had this morning, this bill just needs a lot more work. And the prime sponsor of the bill recognizes that. And so we will support her decision, her request that we interim study the bill. Is there any discussion on Senate Bill 601? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any noes? Okay, there we go. Okay, move consent. Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Matthew, I'll take this one too. Matthew, could you please, when the hearing report is ready, perhaps send the hearing report as well as the testimony we heard in opposition to the bill outlining the issues, so that way the senator can have this, and if she chooses to continue to work on it, she'll have what we've heard. So hopefully it'll work out much better. Okay, we're gonna take up Senate Bill 426. I'm gonna make the underlying motion of ought to pass. Is there a second? Seconded by Senator Gannon. We do have an amendment. It is, I'm looking here, amendment number 1121S. There are a couple of changes here, and some of them we've kind of talked about a little. The first change takes place on line 9 of the amendment that includes, it says transporting alcoholic beverages or marijuana. Lines 12 through 14 really clarifies what we're talking about when we're talking about marijuana, and specifically excluding therapeutic cannabis. We know that here in New Hampshire, therapeutic cannabis is considered a medication, so we want to make sure that is excluded as well. And then finally, I think the one area that we've had some discussions about is what is the least accessible place on a car or an OHRV. And I think we've, beginning on line 27, if it doesn't have a trunk, Such containers shall be stored and transported in that compartment or area of the vehicle or OHRV, which is the least accessible to the driver, or in the glove compartment. I think we've talked about every space on a car except for a wheel well. But I think everyone hopefully can agree, we've heard from everyone and their ideas, and I think this encompasses what we're talking about. Senator Abbas, do you have a comment?
Thank you, Madam Chair. And I know I was a real sticker with some of the language, but the big thing was, I always look at a bill, if I was going to advise someone how to comply with, or to avoid breaking the law, how would I do it? And I just remember last term when I was the chair of the Criminal Justice Public Safety Committee, when I asked a question to someone, when they said, what is the least accessible? I literally use my own vehicle. They named like 5 places. And I'm like, well, what's the least? And I think when it comes to something like this, you know, it can at least be, you can advise someone what to do. And also that makes prosecution of it much easier as well, when it can be kind of arbitrary. So I think this is a good bill. I think the amendment really fixed all the concerns I had. So I thank everyone for their patience in just getting it right.
Thank you. And I thank Mr. Lehman for working on this to get us the right language. Are there any further comments or questions on amendment number 1121S? Okay, seeing none, we had a motion.
Second.
Okay, Senator Abbas, okay. So, we're looking at an ought to pass motion on amendment number 1121S. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a motion on the underlying bill? I think I moved ought to pass on that. Is there a second? Second, Senator Abbas seconds. Is there any further discussion on the ought to pass as amended motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a motion for the consent calendar? Moved by Senator Chandler, Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Oh, no, I'm just going too fast today. So we have, okay, consent calendar. Okay, all in favor say aye. Aye. Any opposed? Senator Abbas, why don't you take this one? Okay, all right, that's all we're going to be doing today. I appreciate everyone coming in. And we still have, I believe, about 6 bills. They're still being worked on. We are going to start hearing House bills on Tuesday. We still have the one Senate bill left that has also been scheduled on Tuesday. So we should have.
one more Senate bill.
Yeah,
Oh,
that's
that's right.
Senator Fenton's bill.
That's right.
We're scheduling it on Tuesday. So we're going to start doing House bills. We're just not going to exec them. So until we get rid of all of our Senate bills. Okay? So, all right, everyone, can I get a motion to come out of executive session? Moved by Senator Gannon, seconded by Senator Abbas. All in favor say aye.
Aye.
Aye. Any opposed? Okay. We're going to close the hearing today. Thank you all very much.